Good afternoon, our distinguished facilitators and our esteemed audience. I stand in today for Mr. Tola Oshobi, SAM, the coordinator for the Civil Litigation Program for this year. The chairman also of the MBA ICLA is unavoidably absent, but without much ado, today promises to be a very exciting session. Our first speaker today is Mr. Babajide Oladipo Ogundipo, very seasoned practitioner indeed, and it gave me great honor and pleasure to take you through his citation, an abridged version of his profile. Mr. Babajide Ogundipe is a founding and currently senior partner of the Lagos law firm Shokunde Osakwe Ogundipe and Belgore. Prior to starting his firm, he worked in Chief Rotimi Williams' chambers for 9 years. In a career that spanned more than 40 years, he has appeared before the state and federal superior courts throughout Nigeria. He has primarily acted for parties in commercial disputes of all types. His practice has also involved advising and acting on behalf of corporations and individuals adversely affected by fraudulent conduct and seeking to recover value lost as a result of such frauds. In addition, over the past 30 years, he's acted as arbitrator in domestic and international arbitrations, covering a broad range of subject matters, from oil and gas related disputes to construction, airline agency commissions, sports sponsorships, defense contracts, and electricity generation under the UNCITRAL arbitration rules, the ICI arbitration rules, the Arbitration Foundation in Southern African International rules, the rules under the Nigerian Arbitration and Conciliation Act, the Lagos Court of Arbitration rules, and the Kigali International Arbitration Center rules. He has spoken at numerous domestic and international conferences on anti-corruption and anti-fraud issues and on arbitration matters. He was a founding member of the Nigerian branch of the Chartered Institute of Arbitrators, where he served as secretary, vice chairman, and the chairman. He was the first president of the Lagos Court of Arbitration. He was the first, and now one of 2 Nigerian members of ICC Fraudnet, a network of specialist asset recovery lawyers organized under the auspices of International Chambers of Commerce, Commercial Crime Services, and a former co-executive director of the network. He was, for more than 20 years, an active member of the International Bar Association and served on the executive of its Anti-Corruption and Regulation of Lawyers Compliance Committee. Mr. Ogundipe is a member of the International Chambers of Commerce Committee on Corporation Responsibility and Anti-Corruption, and presently of the ICC Commission on Arbitration and ADR's task force on issues of corruption in international practice. Please join us, make welcome Mr. Ogundipe as he presents his training for us today. Thank you very much, sir. You're welcome.
Thank you very much, Mabel. I hope everyone can hear me. My presentation today will be, I'll try to make it brief for the specific reason that I have been traveling. I traveled overnight. I had an 8-hour flight. I reached my destination a few hours ago, and I haven't had a great deal of sleep. So you will pardon me if people who've heard me speak before think that I haven't reached the standards that I normally aspire to. I've been asked to speak about judgments and post-judgment proceedings. So I'm going to try to avoid making references to statutory provisions, talking about decisions of court, because you can all go and read those yourself. I'm just going to try and have an outline of these issues. And when I come to the end of dealing with enforcements of judgment, I will come back to a specific issue which has been a bugbear of mine for a number of years. I think the courts have got it wrong, and I would share my perspective with you and leave you all to come to your own conclusions. Of course, I think I'm right and the courts are wrong, but then that is the sort of hubris that lawyers like myself tend to have. So we start off, what are judgments? Well, we all know what judgments are. Judgments are decisions of courts given at the end of a specific process. Um, Usually there's a trial, frequently, or occasionally there's no trial, it's just arguments, but it's a decision given at the termination of legal proceedings. Um, the Constitution stipulates in Section 2941 when courts that are established under the Constitution are required to deliver their decisions, and that includes judgment. It's not just judgments, it's all decisions delivered by courts established under the Constitution are to be done within 90 days. After the 90 days, the courts have a constitutional requirement to furnish the parties with an authenticated copy of the judgment within 7 days. Now, most of you will know that this provision is honored in its flouting. I can't remember when a judgment duly authenticated was delivered within 7 days of delivery. Indeed, many of you will be familiar with situations when judgments, months, even years after having been delivered, are yet to be provided to the parties. Now, that 90-day requirement deals only with courts established under the Constitution. Other courts, such as magistrates' courts, which are not established under the Constitution, will have different provisions. In Lagos State, the Lagos State Magistrates Court at law stipulates 21 working days after the close of trial, which is when a judgment is to be delivered. Now, the delivery of judgments after 90 days was it initially resulted in judgments which were declared beyond 90 days being declared null and void. And as a result of this, the Constitution was amended and Section 294, subsection 5, was introduced, which provided that judgments delivered after the 90-day period would not be nullified unless an appellate or a review court is satisfied that the non-compliance has caused a miscarriage of justice. Personally, I do not understand what a miscarriage of justice in these circumstances would be. There's dicta that suggests the reviewing court's focus would be on whether the delay has affected the ability of the court to determine issues of evidence. That is my understanding of the dicta that exists, but in my view, it's not particularly clear what a miscarriage of justice in these circumstances would be. The next issue that I was asked to cover was the mode of the delivery of judgments. We all know that judgments are required to be delivered in writing under the Constitution, Section 294, subsection 1. And there is some dicta that's been handed down by a number of courts, which stipulate what should be in the writing. It's not just writing, but again, I'm not clear what the dicta means in terms of stipulating what should be in the judgment, what writing needs to be in the judgment. As you probably observe or noted, that I tend to be somewhat critical of some of the decisions that have been handed down in recent times, on unnecessary dicta without clarity that tends to confuse people rather than enlighten them. Anyhow, I'll move on from that before I get myself into trouble. In addition to the requirement for writing, judgments have to be delivered in open court, either actually physically delivered, handed down, or read. Um, I've been I've been in courts where rather than read entire judgments, the court will just read its actual decision. And as far as I'm aware, there have been no challenges to this sort of practice. It makes more sense to me to do this, but some courts will read judgments, take hours. I think the recent Supreme Court judgments in the Presidential Election Tribunal is a case in point, where courts have read judgments and gone on for hours. So I think I'll stop there with regard to judgments and now start with the enforcement of judgments. The first method of enforcement that was provided in the list given to me deals with garnishee proceedings. And garnishee proceedings are simply the attachment by order of a court of a debt owed to a judgment debtor by a third party. That's all it is. It's a method of enforcement which is very, very useful, because if you have knowledge of debts owed to a judgment debtor and the judgment debtor doesn't want to pay, it's much easier to attach those debts in the hands of the debtor, of the judgment debtor, and collect them when you get an order. Collect them from the judgment debtor. The process is an ex parte application to the court for leave to issue a garnishee order nisi, and then at on notice hearing with the garnishees and the judgment debtor present, the court will decide whether or not to make the garnishee order absolute and direct the judgment debtor's debtor to pay the judgment debtor's creditor. It's efficient and it's become very popular. And this is the issue to which I shall return when I have dealt briefly with other methods of enforcement. I was asked to speak about warrants of possession and writs of possession. Warrants of possession are usually issued, at least in the Lagos court, in Lagos State, by inferior courts. And I use that term to distinguish between the high courts and the other courts, such as magistrates courts, area courts, or whatever courts exist in different states around the federation. A warrant of possession is merely an authorization issued by a court to an enforcement officer, giving that officer the power to take control of premises on behalf of a judgment creditor. In Lagos State, these are issued under the tenancy law of Lagos State and the rent control and recovery of residential premises law. A writ does essentially the same thing. However, writs are issued by high courts, and that's essentially the difference between the two. Writ of possession was another issue that I was asked to speak about, and a writ of possession is an authorization to court enforcement officers to take possession of land and premises at the request of a judgment creditor. So it's warrants and writs are essentially the same thing. Then the next method of enforcement of judgment is the writ of FIFA or fieri facias, which is the Latin. A writ of FIFA is the manner by which judgments are executed on behalf of a judgment creditor. The execution takes place in respect of a judgment for a debt or for damages, and it's an authorization to an official of the court, usually the bailiff, to execute a judgment against assets of a judgment debtor, assets of a judgment debtor. The next method of enforcement that I'll turn to is the judgment summons. This is something that in my practice, I've never come across it. It happens extremely rarely, if it does happen at all these days. And all it is it's a procedure under the Sheriff and Civil Process Act, under which a judgment creditor may issue a petition to direct to request the court to issue a summons against his judgment debtor. And the purpose of the summons is to have the judgment debtor examined under oath so that an effort will be made to establish the ability of the debtor to settle the judgment debt. And a debtor who, in the first instance, fails to appear to a judgment summons runs the risk of being sent to prison. A judgment debtor who, if the court believes that he or she has the means to pay the debt, but deliberately chooses or fails to do so, also runs the risk of going to prison, being imprisoned. Under this procedure, the court is also empowered to make orders for the attachment of the assets, other property of the judgment debtor, and its subsequent sale if the judgment debt is not satisfied. And under this process, courts can determine whether or not to, having assessed the financial capacity of the judgment debtor, they can make orders that will result in instrumental payment of what is said to be the debt. I now turn to sequestration. This is another form of enforcement that one very rarely sees in Nigeria. And I'm going to read, and I haven't been doing so, read the provisions of Section 82 of the Sheriffs and Civil Process Act, which is in the following terms. It says, in case the person against whom an order or warrant of arrest, commitment, or imprisonment issued is not and cannot be found, or is taken and detained in custody without obeying the judgment, the court may make an order that a writ of sequestration do issue against its property, and such writ shall be issued and executed in the prescribed manner. The judgment enforcement rules set out the manner in which writs of sequestration are to be sought and executed. It's Order 11, Rule 8, which provides that the writ shall be in Form 69 in the judgment enforcement rules. And it will be directed to 2 or more commissioners to be appointed by the court for the purpose, who shall be commanded and empowered to enter upon all the immovable property of the person against whom the writ shall issue, and to collect, take, and get into their hands not only the rent and profits of his immovable property, but also all his goods and movable property, and detain and keep the same under sequestration in their hands until he shall clear his contempt, or the court shall make other order to the contrary. And the court may order the payment out of the proceeds of such sequestration of all charges attending the execution thereof, including such reasonable remuneration to the commissioners as the court shall think fit to allow, and all the provisions of the rules respecting attachment of property under decree for money shall, so far as applicable, apply in the case of a writ of sequestration. You should all, if you're interested in how writs of sequestration work, read these provisions. There's also Order 4, Rule 13 of the Judgment Enforcement Rules, which provides that a writ of sequestration and a writ of interim attachment directed against any movable property of a defendant or judgment debtor shall not issue out of a magistrate's court, but such writs may issue out of the High Court upon the transfer thereto to the proceedings. So writs of sequestration, like all writs, come out of high courts, and lower courts are not empowered to issue them. Now I'm going to speak about the enforcement of foreign judgments in Nigeria. There are two pieces of legislation which governs the registration and enforcement of foreign judgments in Nigeria. The first is the reciprocal enforcement of judgments, and I'm going to use this term deliberately, reciprocal enforcement of judgment ordinance, as opposed to act. I'm referring to it as an ordinance because it was first enacted in Nigeria in 1922. It's based on a Reciprocal Enforcement of Judgments Act, which was enacted in England in 1920. It sets out a number of Commonwealth territories where there would be reciprocal enforcement of judgments. Then this ordinance was or can be found at cap 175 of the Laws of the Federation of Nigeria and Lagos, as it was then called, 1958 volume. So we had the Reciprocal Enforcement of Judgments Ordinance. It was at cap 175 of the Laws of the Federation of Nigeria of 1958. Then we had another piece of legislation, which was enacted in 1964, but you will find it in the Foreign Judgments. It's called the Foreign Judgments in brackets Reciprocal Enforcement Act, and it can be found in the Laws of the Federation of 1990 and the Laws of the Federation of Nigeria for 2004. Now, the problem with these two pieces of legislation, and if you just bear with me a second, because I need to pull up from, I've done some work on this, and I actually did something similar to this. And the notes that I have do not really deal with the issue in the detail that I need. Damn it. Just if you just bear with me, I'll try and find it as quickly as I can. Now the real issue relating to this point is that we have two pieces of legislation in Nigeria that deal with reciprocal enforcement of foreign judgments. And the real problem arises from the fact that the second piece of legislation, which again is based on English legislation, I don't know how to express this. What happened? Let me just put it like this, right? When the um, second piece of legislation was enacted. It was enacted in a manner that led the law revision committee, or whatever they were called, when they were compiling the laws of Nigeria, to omit the ordinance, the 1922 ordinance. And on the assumption, totally erroneous assumption, that the Foreign Judgments Reciprocal Enforcement Act, which was enacted in 1960, it's Act number 31 of 1960, and based on a 1933 piece of legislation from the United Kingdom. It was assumed that this piece of legislation had replaced the ordinance. It hadn't. And there was, and still is, chaos as to the applicability of the ordinance. As you can see, I'm just trying to bring them up. All right, so we'll go back again. You've got the 1922 ordinance, and then you have the 1960 Act, which reproduces the 1930 legislation. Under the ordinance, judgments obtained in the High Court in England or Ireland or in the Court of Session in Scotland could be enforced in Nigeria upon application to a High Court, and I'm quoting here, within 12 months after the date of the judgment or such longer period as may be allowed by the court. Okay, so you have that. And upon such an application, the Nigerian court could order the registration of the judgment if in all the circumstances of the case, it thinks it is just and convenient that the judgment should be enforced in Nigeria. The ordinance set out a number of circumstances in which judgments would not be registered under the ordinance. These included where the original court acted without jurisdiction, where the judgment debtor was neither carrying on business nor ordinarily resident within the jurisdiction of the original court, and did not voluntarily appear or otherwise submit or agree to submit to the jurisdiction of the original court, or the judgment debtor wasn't duly served and did not appear, even if ordinarily resident or carrying on business in the jurisdiction of the original court, or where the judgment was obtained by fraud, or where an appeal is pending or intended, or the judgment was in respect of a cause or action which for reasons of public policy or some similar reasoning could not have been entertained in Nigeria. If you overcame all these obstacles and succeeded in registering the judgment in Nigeria, the registered judgment would have the same force and effect as if it had been issued by the registering court, that is the Nigerian court. And the Nigerian court would have the same control over the judgment as it would its own judgment, and reasonable costs of the registration were recoverable. Section 5 of the ordinance empowered the Governor General, who was the Queen's representative in Nigeria. That's under the ordinance, and that's what the ordinance, the act, said as at 1958, that the Governor General, upon being satisfied, after receiving information from the Secretary of State for the Colonies, that reciprocal provisions have been made by the legislature of any part of His Majesty's dominions outside the United Kingdom, the Governor General had the power to declare that the ordinance extended to judgments obtained in a superior court in that part of His Majesty's dominions in like manner as it extends to judgments obtained in a superior court in the United Kingdom. Then the Foreign Judgments Reciprocal Enforcement Act. I said it was passed by the Parliament of Nigeria in 1960, and it took effect on the 1st of February 1961. And as I said earlier, it sought to replicate the 1933 UK Foreign Judgments Reciprocal Enforcement Act. And that of 1933, the 1933 scheme was designed primarily for non-Commonwealth states with power to apply it to, again, we're using language of 1933, to His Majesty's dominions and to other parts of the Commonwealth. It was also intended to remove the common law enforcement action. And I'll come back to the common law enforcement action. And it was intended eventually to supersede the 1920 scheme. Now, what has happened is that with this 1960 Act coming into effect, people thought that it had actually superseded the 1920 scheme. As I said earlier, it hadn't, and I'll make reference to a number of cases that have confirmed that this is the position. Now, the head note to the 1960 Act states that its purpose is to make provision for the enforcement in Nigeria of judgments given in foreign countries, no longer Commonwealth territories, no longer His Majesty's dominions, in foreign countries which accord reciprocal treatment to judgments given in Nigeria. That's the second aspect of this. It's foreign countries that accord reciprocal treatment to judgments given in Nigeria, and also for facilitating the enforcement in foreign countries of judgments given in Nigeria. Now, so it's reciprocal, which means that the foreign countries have to treat Nigerian judgments in the same manner as, and so that's where we have it. Section 3.1 of this 1960 Act empowered the Minister of Justice, and I'm quoting, if he is satisfied that in the event of the benefits conferred by this part of this Act being extended to judgments given in the superior courts of any foreign country, substantial reciprocity of treatment will be assured as respects the enforcement in that foreign country of judgments given in the superior courts in Nigeria. And that if he is so satisfied, that's the end of the quote, if the Minister of Justice is so satisfied, he may, by order, direct the extension of Part 1 of the Act to such foreign country that provides reciprocity to Nigerian judgments, and that courts of such foreign country shall be deemed superior courts of that country for the purposes of Part 1 of the Act. And Section 2 provides judgments of superior courts of countries to which Part 1 extends should be final and conclusive between the parties, be for the payment of a sum of money other than in respect of taxes, fines, and penalties, and have been given after Part 1 has been extended to such country or judgment to which Section 10 of the Act applies. There's some other stuff, but I think for these purposes, and I will share through the organizers this what I prepared. But what is significant here is that the Act only applies with respect to foreign country judgments of foreign countries after the Minister of Justice has extended the Act to those countries. Now, the problem we have is that the Minister of Justice has never done this. Since 1960, it's 2024, 64 years later, it has not been extended. So in terms of reciprocity, there is no provision for reciprocal enforcement of foreign judgments in Nigeria. That is a fact. However, Nigerian courts, in their wisdom, in a number of cases, have given decisions that I, as well as a number of other commentators, academics. I'm not an academic, I only have one degree. I've never taught anybody anything academic. So I don't consider myself to be academic in the slightest. But the Nigerian courts have applied the 1960 legislation, 1960 Act, as if the Minister of Justice had actually extended it. So I'll pause there and go back to the confusion that existed as to whether or not the ordinance continued to be in force in Nigeria. As I said earlier, in 1990, the revised edition of the laws of the Federation omitted the ordinance. And there was confusion for a number of years as to whether or not the ordinance remained law in Nigeria. The issue was settled in 1996 when the Court of Appeal held that the ordinance had not ceased to exist, and for the purposes of the particular case before it, it was the applicable statute. That case is, I believe, still well, it might have been reported now. When I first started looking at this, it was unreported. It was decided in July 1996, and it wasn't reported. So in 1996, the Court of Appeal said, ordinance continues to apply to Nigeria. And then what about the 1960 legislation? In 2003, the Supreme Court said this with regard to Part 1 of the Act, that it applies to all Commonwealth countries as it applies to foreign countries, and the 1958 ordinance ceases to apply to them except those to which it was extended before the Act came into operation. There's a full stop at the end of that quote. I'm going to continue quoting, but I pause to say that the ordinance only applied to a limited list of countries, some of which, in terms of today, and indeed, as at the time the Supreme Court said this in 2003, those territories no longer existed, right? So, I mean, there's confusion there. But the Supreme Court went on. The Act came into operation on the 1st of February 1961. This section is not automatically extending Part 1 of the said Act to Commonwealth countries other than Nigeria. All it was saying was that the provisions of Part 1 of the Act shall apply to the Commonwealth as it applies to foreign countries, and where the ordinance had been extended to any country before the commencement of the said Act, the ordinance ceases to have effect. Ordinance hadn't been extended to any countries other than the ones that were listed. The court observed that the Act empowered the Minister of Justice to extend Part 1 to foreign countries and noted that this had yet to occur. 3 years later, after a further revised edition of the Laws of Federation was published in 2004, again omitting the ordinance, the Supreme Court revisited the issue and held that the 1961 Act was also applicable. And we have seen that until the Minister of Justice extended it to other countries, it really didn't cover any countries. But the Supreme Court held that the 61 Act applied by virtue of a proviso to Section 10, even in the absence of a ministerial order extending the application of the Act to any country. And Section 10 commenced with the phrase, notwithstanding any other provision of this Act. And the Supreme Court construed that clause as enabling Section 10 to be applied and to make the registration period 12 months as opposed to 6 years. They have adhered to this construction of the 1961 Act, and they have gone on to permit the registration in Nigeria of judgments from Virginia in the United States, from Liberia, and from Niger. Now, I can state categorically, the courts in these jurisdictions do not grant reciprocity to Nigerian judgments. Bearing in mind that the title of the legislation contains foreign reciprocal and enforcement of foreign judgment, reciprocal enforcement of judgments. How our courts were able to permit the registration in Nigeria of judgments from these territories is a puzzle that I certainly cannot unravel. Someone, not myself, has described the case law that we have in Nigeria as rather incoherent. And some people might think it's exceedingly mild language, given where the dicta of the Supreme Court and the Court of Appeal are clearly per incuriam. Lower courts will nonetheless apply them due to the manner in which the doctrine of stare decisis is applied in Nigeria. So we have this difficulty with the reciprocal enforcement of judgments. That's judgments enforcing them in Nigeria on the basis of some arrangement with foreign states. Thankfully, or maybe not so thankfully, there's a common law right to enforce judgments. You could sue on them, but there's significant differences of opinion amongst commentators as to whether indeed the common law method of enforcing judgment continues to subsist. I think it does, and until there's some decision on it, it's difficult to say how it's going to go. I believe I got 15 minutes left, so I just want to come back, and I said I would do this at the outset, to another situation where I think that Nigerian courts have got things wrong. And this is to do with garnishee proceedings. As I said, garnishee proceedings, a garnishee is simply the attachment of a debt owed to a judgment creditor. I'm sorry, a judgment debtor. And this is most frequently done. When we see these proceedings in Nigeria, they usually involve banks. And the reason for that is that when you put your money into a bank, you're lending the bank money. So the bank owes you money. So the bank is a debtor of yours. And if you have money in the bank, your judgment debtor can go to the bank and say, bank, you owe money to my judgment debtor, so please pay it over to me. And this is personal to me because I conducted a case involved the Lagos state government, and I got a judgment from the Court of Appeal where the Court of Appeal held that, notwithstanding the pendency of an application to stay proceedings, to stay the execution of a judgment, an application for garnishee and for a garnishee order nisi could nevertheless proceed. I have the citation for the case which I did, and it will be in the document that will be shared by the organizers. But at least two subsequent decisions have held that and these are decisions of the Court of Appeal. So the one that I did involving Lagos State was a Court of Appeal decision. Subsequent judgments have said that where there is an application for stay of cannot be issued. And I find that difficult to understand because if one looks at the language that created these things, it's clear that the garnishee is not a method of execution of a judgment. Execution of judgments is done by writs coming out of the High Court or in lower courts from warrants. And the execution is against the goods, the property of the judgment debtor, against the property of the judgment debtor, goods, physical things. When you see, you don't see it so much these days, but back in 20 years ago, courts were littered with items, cars, and other pieces of that turned to junk that had been taken in execution by bailiffs. It's so execution is physical execution. The garnishee proceedings is attachment. There's nothing physical about it. It's an order from a court that says that debts owed to the judgment debtor can be taken as in the first step. Nisi, they are charged to the payment of the judgment debt, and then you have an apologies. I'm back. The last time I spoke about enforcement of judgments, the same thing happened. So I don't know whether it's an omen. It's telling me to shut up. So I was saying that garnishee and executions are fundamentally different things, and I think that the decisions that exist are wrong. And I'm hoping that an opportunity will arise where this can be addressed and arguments can be presented to the court to demonstrate that they are completely different things. In the decisions that I've looked at, I don't believe that the courts heard any argument about the fundamentally different nature of writs of execution, the processes of execution, as being just one method of enforcing the judgment. So I think I will stop there and answer some questions. I have one in front of me, which I'm looking at now, which says where a court has ordered a bank to reverse money erroneously transferred to an unintended party, and the bank fails to carry out the order for reasons that the amount in the account is less the amount ordered to be reversed, can garnishee proceedings be commenced against the bank as garnishee and the party on whose account the money is located as a debtor? I'm not clear exactly what this question has in mind, but I think what has to be stressed is that you can only start garnishee proceedings pursuant to a judgment having been obtained. So there must be a judgment in existence. The judgment must call for the payment of money from one party, and it is only in those circumstances that garnishee proceedings can be commenced. And then there's another question. It says, in general, the consent of the Attorney General is a prerequisite for garnishing the account of the federal government. It's pertinent to determine whether the same consent is necessary before garnishing the account These are other talking about garnishing the account of the Abuja Municipal Area Council, which operates similar to a local council. And then there's a question, can contempt proceedings be used to enforce monetary judgment? It's a good question. I'm not sure what the answer is. I don't believe so. But it's possible if the monetary judgment is in the form of a direction to a party to do something. It's possible, but I view this as being very, very different from enforcement of an order for the payment of money. I hope that answers the question. So I think my answer to this question is in the negative. So any other questions? Or can I hand over to his lordship? There's a question here that I'm looking at. Can the judgment debtor appeal an order nisi or an order absolute? Well, depends on the nature, on the basis of the appeal. Appeals are not premised on subject matter. It's premised on issues of law, whether it's final, etc. So there might be circumstances in which a judgment debtor can appeal an order nisi, or should be able to appeal an order absolute if it deals with issues of law. I would imagine so. There's a question here. Many times, the garnishee banks depose to affidavit the judgment debtor has no account with the bank in question, while in most cases the reverse is the case. What option would be available to the judgment creditor? I think if you have evidence that the bank is not being truthful, there's issue of as it's essentially contempt. There's word escapes me now. You can pursue the bank. Definitely, you can pursue the bank. The bank hasn't been truthful. Other question: what happens in a situation where an applicant applies for the consent of the Attorney General and the AG does not expressly give nor deny consent, having acknowledged receipt of the application? I have something that I'm interested in pursuing with regard to whether or not the Attorney General's consent is actually required, looking at rights of parties under the Constitution. I don't think this is the appropriate place to actually pursue that, but it's something worth thinking about. Then there's another question here which says, can the judgment debtor who is not ordinarily a party to garnishing proceedings object to the issuance of an order absolute where there's no valid appeal or order of state execution? My answer to this would depend on the circumstances. Essentially, the proceedings are between the judgment creditor and the garnishee. So the judgment debtor, he can assist the court, but I don't really see what he's doing there. He hasn't paid and he hasn't appealed. The next question is Section 2 of the Foreign Judgment Reciprocal Enforcement Act defined judgment to include arbitral award. Do you think foreign arbitral award annulled in deceit and incapable of enforcement in Nigeria Section 4 can still be enforced under Article 58, which gives the enforcement court a measure of discretion in enforcing annulled award? This is not an easy thing to answer. I think a great deal would depend on, it's not just the Arbitration and Mediation Act. We've also ratified the New York Convention, which deals with the enforcement of foreign arbitration award. So I would advise that one looks at that, and I haven't considered that for a while. The next question says, judgment enforcement rule was made pursuant to Sheriff and Civil Process Act to inform us who made the rules and under what circumstances will the rules not be applicable. I can't answer that question now. I have to look at the rules. It'll tell you who did it. Another question here says, does it mean that a foreign judgment other than judgment obtained on matrimony cannot be registered in Nigeria and enforced here? I don't know the answer to that. I indicated we have situations where on a statutory basis, registration is on a statutory basis. The statute doesn't, the statute states when and under what circumstances judgments can be registered in Nigeria. Nigerian courts have ignored the provisions of the statute and registered judgments here. So I think it's essentially a lottery. The next question is, can a judgment obtained in the Federal High Court, Lagos, against a defendant with head office in New Mexico, be executed in Mexico? It said, but I'm assuming that that is New Mexico. I doubt it, but it is what the law in New Mexico will be the determinant factor for that situation. Can a secretary in a law firm depose an affidavit in support of an application for order nisi? If the secretary in the law firm has knowledge of the facts, direct knowledge of the facts, yes. But if he doesn't, then clearly he cannot, or she cannot. Those are all the questions that I've seen. Mabel.
Thank you very much, sir. I guess we're out of time. There's another question here, and my Lord is already in.
Yes, I've seen him.
Thank you so much, Mr. Ogundipo. We're indeed very grateful for your time, and we're grateful that you've been a very insightful training this afternoon, and we're very grateful that you obliged us. Have a very good afternoon.
Thank you. I will send stuff. I'll send stuff through to you when I've revised it and put together, including the stuff to do with enforcement of foreign judgments.
Thank you. There's still questions coming in. Perhaps we should come and seek legal opinion for you.
Well, what I'll do is I'll shut off my camera, mute, and I will answer them.
You're muted, sir.
I wanted to stop the video. I said that I will type answers to the questions whilst His Lordship is making his presentation, so I don't eat into his time.
Thank you very much.
Good
afternoon, my Lord. You're very welcome. It's my
good afternoon or good evening.
Good evening, my Lord. It's my honor to read out my Lord Justice Ibrahim Buba, retired, abridged profile ahead of his presentation this afternoon. Mr. Justice Ibrahim Buba was born on the 1st of January 1958 to the family of Malam Buba Nahiru Malabu and Hajia Zainab Abubakar Hajia Bubu of Najaiwa on the Mambila Plateau, Sadauna local government area of Taraba State, one of the most beautiful places in Nigeria, the highest place in West Africa, the home to second mountain of death on earth. Justice Buba had his early Quranic education in Dawi and was in the first pioneering set of the pupils of the LAA Primary School in Jawai, 1969 to 1975, where he was a class captain and monitor. Young Buba proceeded to government secondary school in Gembu in 1975 to 1980. Buba, a basketball player and a long-distance runner, represented GSS Gembu in basketball competitions and Gongola Boys Ellison Trophy in 1977 and came first in 5,000 meters and also caught up with the record of the then Olympic medalist of Kenya in 5,000 meters. Buba also represented in school, in sports at Tekum, in Yola. He was the vice house captain in Shiroma House and head boys of GSS from 1979 to 1980. He was a library attendant at the Federal School of Arts and Science in Nubi, August 1980 to November 1980. He was in College of Preliminary Studies in Yola from November 1980 to December 1980 and left for University of Maiduguri in January 1980. Justice Buba obtained his LLB from the University of Maiduguri, Nigeria in 1985 with a second-class honors upper division. He attended the Nigerian Law School in 1985-1986 and obtained his BL with a second-class upper division and won the Sir Lionel Brett Award for overall best performance in criminal procedure. He was called to the Nigerian bar in 1986 and undertook his NYC in the defunct Bendel State as prosecutor in the Ministry of Justice, Benin, with the DP. After NYC, he started his law practice in the firm of Messrs. Abayoni and Co. That's Olaoluwa Chambers in Yola State. That was in 1987. My Lord Justice Buba later left for University of Maiduguri and was an assistant lecturer in the Faculty of Law from 1987 to 1988. The Lord was indeed adventurous, left the classroom at the University of Maiduguri for Kaduna in 1988 for legal practice in Godia Chambers, and in 1989 he established Ibrahim Buba and Co. Saha Chambers in Kaduna State. Later, with branch at 284 Ahmadu Bello Way in Gembu, upon creation of Taraba State from the defunct Gongola State. The Lord Buba was a founder and partner of Farmer Firm at 36 Ali Akilu Road in Kaduna. He was active in practice in Kaduna, a member of the Kaduna Bar. He served as financial secretary and secretary of the NBA Kaduna, a member of the Kaduna Local Government Elections Appeal Tribunal, the notary public, remained in active practice until he was appointed as a judge on the 26th of November 2003. Justice Buba is the first pioneer lawyer and the first pioneer judge from Mambila to Sadauna, local government area of Taraba State. He was appointed a federal judge in November 2000 and was sworn in on the 7th of January 2004 at the age of 45, and as the number 45 judge on the bench. Was a pioneer presiding judge of the Federal High Court at Sina Division from 2004 to 2006 and has served in various divisions of the Federal High Court, including High Court from 2006 to 2008 to Jos from 2008 to 2000, between April and July in 2008, and he pioneered the George Lafayette Division from 2008 to 2010, and the Asaba Division, the Lagos Division, the Enugu Division, and his last division, Bauchi in the Northeastern Zone, October 2022 to December 2022. Justice Buba has delivered various landmark decisions in commercial law, administrative law, admiralty law, constitutional law, criminal law, terrorism, and insolvency matters as a federal high court judge. He attended training and conferences in Washington, New York, Singapore, New Delhi, amongst others. He was nominated by the Honorable Chief Justice of Nigeria to represent Nigeria in the Special International Forum of Commercial Courts in London, New York, Singapore, Australia in his first, second, third, and fourth meeting. And he interacts with Chief Justices, judges, and judges of judiciaries world over. He is a regular speaker at the National Judicial Institute and has delivered several lectures to judges, prosecutors, investigators, both within and outside the country. He is widely traveled and knows every nook and corner of Nigeria, speaks many Nigerian languages, and understands the cultures and way of life of Nigerians. A federal Peking, a judge, a farmer, and a family man. Justice Buba has an insatiable appetite for reading and search of knowledge. A father, grandfather, health, energetic, philanthropic. He loves music, sports, reading, and making friends. And he loves his family, his village, that's Nigeria in Mambila Plateau, a typical rural man that takes challenges of life as they come, believing and trusting in the will of Almighty God, and not lacking in courage as when the occasion demands. Justice Buba attained the then statutory age of retirement 65 years on the 1st day of January 2023. A friendly judge to all staff and judges of the Federal High Court, and indeed other judges of the various courts within and outside Nigeria. He was conferred and holds various titles, a traditional title holder, Walin Mambila in Sardauna Traditional Council of the Sardauna Local Government Area, Turanki Gas. My Lord, please forgive my pronunciations. Justice Buba is also the Sarikin Yaki Kuma Chief Don, and amongst others. Without much ado, I present to you Honorable Justice Buba for today's session 2. Thank you very much, my Lord.
Good evening. Am I audible?
Yes, my Lord.
I have looked at as a timekeeper, Mabel Okereke took about 8 minutes or 9 minutes reading my abridged biography. Thank you for that. So I won't bore you. I won't take more time. You've already taken 9 good minutes from our discussions. Probably that will also assist me in case I am stuck. At least I exhibit regrettable ignorance. The most important part of dispute or conflict resolution is the decision or judgments of courts, whether interlocutory or final. And the saying is that fortunate indeed is one who has been able to resolve conflict within a reasonable degree of competence, a reasonable degree of time, so that the impact of the moment will be achieved or established in future perspectives and priorities. And that is the hallmark of Section 36 of the 1999 Constitution, i.e., judgments and orders are usually the determinations of rights and in the actual circumstances of which the court has cognizance and giving some particular relief capable of being enforced. I think that was what the Supreme Court said in Okoya and Santilla. Thus, no judgment of a competent court of law should go forth without respect and come back without effect. Judgments and decisions of courts in Nigeria are to be enforced by all courts. If you look at Section 287 of the 1999 Constitution, subsection 1, 2, and 3. So consequently, judgments are to be enforced. They are to be given effect. They are not to be hollow or fruitless. Then that brings me to our topic, preservative proceedings pending appeal. Simply put, the suspension of the execution and enforcement of judgments or decisions pending the happening of events that are certain in our cases pending the hearing examination of appeal. Sought as order of stay of execution prohibits a judgment creditor to execute said. I think that is how I understand the topic. Preservative proceedings pending appeal. In other words, stay of execution, but with judgments. It could be interlocutory, it could be final. There are also judgments, they are all decisions. And I won't bore you with theory. I'll try to be very practical, being a training. Generally, judgments in Nigeria are enforced through the Civil and Sheriff Process Act, that previous speakers. Enforcement of judgments, rules, sheriffs and civil process laws of various states of Nigeria. And of course, there are a lot of literature when it comes to enforcement of judgments in Nigeria. I'm sure members of the legal profession are very conversant with SS by Obi Okoye in volumes. I'll refer you also to volume 1, pages 101 to 107, paragraphs 188 to 203. I will also not bore you. I will also refer you to SS on civil proceedings by one of our previous speakers, S.T. Horn, SAN, and all of them deal with these issues of suspension or preserving judgments. Why must judgments be preserved after they are given? Of course, judgments once given take effect immediately. unless and of course there is where leave is required to enforce them. Otherwise, until the court stay them. And every court, superior court in Nigeria, have inherent jurisdiction to stay judgments and or suspend judgments or preserve them pending the happening of events. In other words, though judgments are given, the fact that they are given does not necessarily mean they must be enforced. Sometimes we suspend them or we preserve them until appeal is heard and determined. And that brings us to the heart of the paper, or what I call the center of gravity in our discussion this evening, or this afternoon rather, late afternoon. Now, it's very easy for people who are not in the legal profession to mistake certain proceedings in our adversarial system of administration of justice, i.e., a person who has come to court after wasting so much time, so many years in court, when judgment is given, finds it very unacceptable that he cannot get the fruit of his judgment immediately. But that is not so. The proceedings in our system of administration of justice does not start and end in a trial court. Proceedings start from the trial court and run through the entire judicial hierarchy up to the Supreme Court, and it is one case, unless if no appeal is filed. Once appeals are filed, it is a continuation of the process until it goes to the final court of the land. And then we all know courts in Nigeria are congested, not only in Nigeria, the all over. In fact, in the urban cities of the so-called developed countries, there are more congestions of courts than in Nigeria. So therefore, when cases go through the whole ladder, it becomes very difficult and not understandable for some people why they cannot get the fruits of their judgments immediately. And therefore, the first area I want to look at is stay of execution. Of course, the principles we all know for grant of stay of execution and stay of proceedings are almost similar or the same, except in few occasions where they part, including injunctions pending appeal. All these things also have principles that overlap. But today, as I said, is not a day of theory or reeling out cases for you and the principles, but to look at it from a practical and utilitarian value to a practitioner who is really learning the ropes. Now, always, when parties secure victory in court in judgments that are executory, they will want to quickly rush to court and get their fruits. But the adversary or the other side too, who are aggrieved, will always want to test the decisions. And of course, they have a right of appeal up to the final court of the land. Now, our court system, except when parties settle out of court and file terms of settlement, you always find one aggrieved, one happy. For every decision given, one is aggrieved, one is happy. So for the man who is aggrieved, he has a constitutional right to pursue his grievances until he gets to the final court where there are rights of appeal. Of course, once appeals are filed, the losing party will always want to rush to court quickly and say he wants to stay execution until his appeal is heard and determined. And of course, the winning party on the other side will also want to make sure he does not get the stay. But oftentimes, when applications for stay of execution comes before the court, you find that there are a lot of problems. There are rules of court to be obeyed. For instance, in the Federal High Court where I left, applications for stay of execution must be filed within a particular time. Time frame is given. You must also compile records of appeal and also make sure they are transmitted within that time. Otherwise, if that condition precedent is not made, automatically an application for stay of execution will suffer defeat. But principally, why will a court stay execution of its own judgment? It is necessary to allow the aggrieved party to test the judgment. And if by the nature of that judgment, and it is not stayed, and an appeal goes up and is overturned, Whatever happens in the Court of Appeal or Supreme Court will be rendered nugatory. That is the whole essence or the principles behind stay of execution, to ensure that whatever happens in the Court of Appeal, the lower court or the situation will not be rendered helpless. To that extent, principles have been evolved over the years. Since 1800s, in 1885, the case of Baker and Ladry in the Queen's Bench Division, and the case of Wilson and Church in 1879, Chancery Division, where we borrowed our system of administration of justice, evolved the rules that a winning party in the court below should have the fruits of his judgment or his victory. That has been decided by a long legion of authorities and also followed by our Nigerian courts in cases like Didu and Okorodudu, Baswani and Savalak. Like I said, I won't bother you with theory. They have been. But for one that is like, what is critical is that for you to have an application for, say, stay of execution, you must, though there are authorities that say whether with or without notice of appeal, sometimes you can apply, but invariably, the basic rules or principle is that you must have a notice of appeal, a notice of appeal that is valid, filed within the time allowed by rules of court, and valid. And if the notice of appeal is supposed to have, you are supposed to obtain leave in issues of grounds of mixed law and facts, you will have obtained it. Otherwise, if there is no valid notice of appeal, an application for self-execution will have no faith in any court in Nigeria. And unfortunately, grounds of appeal, how they are being couched are not taught in the law school. Grounds of law, grounds of mixed law and fact, of course, if you read cases like Ogbeche and a group of cases, I will not give you citation, you read them, you find how grounds of appeal are filed. So for anybody learning the ropes, he must know how to file proper grounds of appeal. If the notice of appeal is invalid and incompetent, there's no point wasting time to start filing an application for stay of execution. That will be the first hurdle. The party filing the notice of appeal, he must also attach it. You cannot just come with an application for stay of execution and read facts in an affidavit without attaching a certified true copy of the notice of appeal to your application. In fact, the affidavit is the vehicle. It must be loaded. It's better always to look at the decided cases and put the principles side by side while one is drafting his application for stay of execution. Look at the grounds and be sure you have complied with all the things that are required, i.e., your notice of appeal is filed within time, the grounds are proper, while leave is required, you have obtained the leave. Once a valid notice of appeal is before the court, that is the foundation and that is the beginning of an application for stay of execution. And you must look at the principles. The affidavit must be loaded. You cannot leave anything to chance. The depositions must refer to all these principles that are required. Of course, the principles are all in case law, which I will not bother you, like I said, with the theories and the competent notice of appeal, special circumstances. All these, I take it for granted, are well known to anybody who is in the legal profession. But the point I want to emphasize is that affidavit, which is the vehicle that you want to convince a trial court, and indeed, by extension, an appellate court, must be loaded and it must comply with all the condition precedents. Because the first point of call for filing motion for stay of execution is in the trial court. If it's not granted, then you move on and also file in the appellate court. And all these things have their own principles. One filing an application for stay of execution in a trial court must always bear in mind the advice given by Nikitobi, JC as he then was, of blessed memory in General Oil against limited against Oduntan. I'll skip the citation. Because the worrying point, or what his lordship explained, is that you are approaching a court that has given judgment against you, that is convinced you have no case. You want to convince that court that, look, this judgment is also faulty and is to determine the strength of his own ruling or decision. And because of that, you must be very careful to try and convince the trial judge, who is also a human being like you, that, look, you are not talking about his judgment. His judgment has been given. Whether it is right or wrong, he has a constitutional right to err as a trial court. It's within his jurisdiction, but you want to test it. You have to convince him that there are arguable grounds of appeal in your notice of appeal. And the notice of appeal is valid, the grounds of appeal are arguable, and you have chances to succeed in the court of appeal. And you must also bring out from your affidavit clearly that in the unlikely event of that court not staying execution, greater harm will be done. Because it's not every judgment that must be stayed. You must distinguish between executory judgments and judgments that are merely declaratory, there's nothing to enforce. You must be able to show the court that, look, my lord, if at the end of the day the appeal succeeds, there will be nothing for me as a victorious person or as a loser. And even the loser, if I win on appeal, I will come back, nothing will be restored. And that's the hallmark of the case of Aswani and Savalan, that exceptional and special circumstances. Of course, an application for self-execution is also at the discretion of the court. Like every other discretionary relief, you should be able to bring out things that will sway the mind of the court to exercise discretion in your favor. Of course, judicial discretions, we all do know, are to be exercised not arbitrarily. Like my friend and an old lawyer I know, Osahin Ozamir, will say, a discretion without criterion will be an authorization for arbitrariness. No judge will act arbitrarily. You have to put the materials before him, and once the materials are before the court, the rest assured, notwithstanding the judge has given judgment against you, you will be persuaded also to stay. There's nothing personal about the judge. He has no Panadol to take. The duty of the judge is to decide. He must decide. He cannot refuse it. Once he has decided, that is the end of it. The rest is for the appellate court. So it's left for a practitioner to load his affidavit, make sure that the discretion is exercised in his favor based on the materials that he has placed before the court. And he must convince the judge that the rest is what is being targeted and looked at, not just the judgment per se. The fact that your chances on appeal are favorable is not enough. You must be able to show arguable grounds of appeal is not enough. You should be able to convince the court that this rest, if it is not preserved and the judgment is enforced, at the end of the day, injustice will be done. And this is the way I think lawyers should be able to approach and convince courts how, and a court will be able to look at. In that way, the court will be able to look at your application with a sympathy and also with an healthy seriousness and grant same. But if you just leave the affidavit evidence loose, for instance, it's a money judgment, you just depose you are unable to pay, no court will be persuaded to grant you. If you say you will not be able to prosecute your appeal because of poverty or because of financial constraint, you should be able to depose your financial stand and standing before the court. If it's a company that you think will not be able to prosecute or its appeal or will be wound up as a result of the judgment, you should be able to put the statements of account before the judge hearing the application for stay of execution. And these are elementary. Our law reports are replete with authorities on stay of execution. The principles are also there. I will not read all of them to you, but bear in mind, at the beginning I said, put the principles side by side with your, when you are putting your affidavit and your exhibit, make sure you comply with that. And having said that, many a times you see people come to court, ask for stay of execution of judgments that are merely declaratory. Of course, I'm not oblivious that in cases like election petition, there are times, even though you have declared, the party is declared, it's not good for the system within few weeks to keep changing people in authority in government house. At times also, even that in that case, we still have to convince the court that you deserve a stay. Otherwise, somebody will be sworn in. And this is the way I want us to look at this topic of preservative proceedings pending appeal, because everything is dependent on appeal. But at times, it is not only when there is an appeal. If it's a money judgment, you ask for instrumental payments. There's no appeal. Like I keep saying, it's not every time you ask for stay of execution that there must be an appeal or a notice of appeal validly filed. You can have a stay or a judgment preserved when there's actually no appeal, no notice of appeal, i.e., while you approach the lower court to stay execution and you want to pay the judgment sum instrumentally. In that case, again, it's left for the practitioner to make sure that he has convinced the court that the judgment will be paid instrumentally and the reasons are also cogent, and that the court will be persuaded in granting the relief. There are other areas also that you may think interlocutory injunction or appeal to have a capacity, or there are also ways of preserving the judgment. Interlocutory injunctions, just like in the trial court pending the hearing in final results, can also be granted even on appeal. Of course, the principles again are well known to us. I will not bore you with cases like I said, Basawani and Sabalak, all the Okafan and Naife. There are cases that are well known even by law students. But let us use the practical part of it. It was Gungi Watingo who said, knowledge of the law stuck in the head would not win a battle in court. Now, the way we craft our applications to get a judgment preserved matters a lot. It's not a matter, it cannot be granted as a matter of course. It must be borne out by affidavit evidence or other reasons that are convincing that this judgment should not be executed. If it is executed, injustice will be done. So that is the point I want us to look at. And I will not take so much of your time. The principles, there's a paper I had already sent out, but I know it will be circulated. There are the normal rules that you read in your law reports. But I would always want to advise anybody moving or seeking to reserve a judgment should understand that time is also of the essence. His conduct also should not be impugned. It's an equitable remedy. Like all equitable remedies, we must come with our hands clean. If a particular applicant had been in the trial court, frustrating the hearing of the case, coming to court, stalling proceedings, if at the end of the day judgment is given against him, one can refuse to file a counter affidavit. I will merely come and refer to the record of the court if they are on matters that are already known before the court, that the conduct of this applicant does not deserve any sympathetic conduct. They have been in disobedience of the court order previously. They have not purged. They have not obeyed any order. They have not paid money. In fact, their intention is not actually to pursue an appeal, but to frustrate his adversary. So such a thing should always be also looked at when you are opposing an application for a stay of execution or for preserving a judgment. You have to also come handy, because it's not a must that an application for stay of execution should be granted. It's on the adversary also to bring out the inadequacies of the application, i.e., no record of appeal has been transmitted. There is a delay, i.e., no compliance with any order of the court, i.e., the intention of the applicant is really not to pursue an appeal, but to frustrate his adversary and make sure by the time the fruit of judgment is given, even in monetary judgment, the money has no value in terms of inflation. You can imagine a case staying in court for 20 years and you are just given a paltry sum of money that cannot even pay legal fees. I can tell you an example. In the case of Pategi and Moazu, I had, as a young practitioner in Kaduna, my client's vehicle was involved in an accident. The valuation of the car was 45,000. When we went to court, we got judgment in the trial court before Justice Akas J, as he then was. He awarded 5,000 naira to us because we did not prove, according to the trial court, the pre-accident value of the vehicle. By the time we went to Court of Appeal in Kaduna, Justice Obadino, JCA, reversed the decision of the High Court, granted us the 45,000. We went to enforce. The defendant, respondent, was nowhere to be found. we found out he died a year before the appeal was determined. So these are some of the problems you go through in our system. So you can imagine after so many years, even if we had been given 45,000 naira, it would have been nothing in terms of inflation. But at the end of the day, we even got nothing. So these are the kind of things you should be able to bring out, even from case law, to show the court convincingly that if a stay is granted, at the end of the day, you will be the worst. Of course, it's always better. What I used to do in practice, look, I don't want to oppose this application. I want them to deposit the money in an interest yielding account so that at the end of the day, whatever happens, even in money judgment, we will not lose totally. But in the situations where items are perishable, a house, even in land matters, that the property will be altered, it will be changed completely. When you need the stay, you have to bring out all this out as a matter of evidence in your affidavit. So I will not read all the principles so that we will have time to discuss. And I'm also the timekeeper. Mabel, I think we have 4:34 now. Mabel?
Yes, my lord.
Hello? Fine.
Yes,
so,
my lord.
So the paper, which is more theoretical, will be circulated for everyone to read. I want us really to look at our own system, the way we operate. When your adversary is set out to frustrate you by applications for stay, you also be ready for him. In fact, if need be, I used to compile records for the adversary as a practitioner so that he will have no excuse to say record is not compiled. But of course, in Nigeria, when you are practicing today, you also know about Court of Appeal and the Supreme Court. There is no limit to right of appeal people can bring. Today in Nigeria, if you cough as a trial court, you smile, it will be a ground of appeal. Our appellate courts are overburdened with appeal processes. So at the end of the day, if you are locked up in the Court of Appeal, appeals cannot be determined in a week or a day in Nigeria. So in such a situation, it's left for you also not to give them an opportunity. If an appellant's brief is served on you, you must also quickly file your respondent's brief. Otherwise, if there's an application for stay, an adjournment could be number of years that you will not be. Of course, we know about the court congestion in Nigeria. You also have to try to bring this out to show to the court that bring out statistics from the Court of Appeal and the Supreme Court that appeals that are being had now are in 2008 or 19 so, and show the court that there is no need to grant stay. Let the money be deposited if it's a judgment sum in the court of law. But of course, there are some cases by their very nature. The court has no choice but to stay. Otherwise, if the rest is destroyed, there will be nothing. And an appeal an aggrieved person's appeal will be frustrated. So in essence, what am I saying? We should try and look at the rules of court. Try and look at the principles enunciated. The appellatory and the law is very clear now. Anybody coming to court, you can punch your button. We are living in the world of technology, and read all the principles and make sure they are on your side and in your favor. So I think I don't want to talk too much on it, but there's something I wanted to conclude on, but maybe when we got questions and answers, I will come to it. But you should be able to extract special circumstances in all cases to enable you preserve proceedings pending appeal. If you are unable to extract that special circumstances, of course, special circumstances, there is no definition. It's very fluid, it's very nebulous and precise. It's left for you to bring it and convince the court, look, this is a special circumstances. This my daughter that they want to take away custody from me is already in school. If she leaves that school and goes to another school, it will retard her progress. And it's left for you. It's not an issue of emotions, but sometimes you have to. The issue of stay or preserving judgment is not an emotional issue. There are issues that are really factual that every litigant should be able to bring them out for the court to see and persuade or sway the court to grant the application. I think thus far, I've spoken a lot, copying from S.T. Horn's book, Civil Proceedings, Aguda, Wadialo, all of them, they are replayed. But what I want to advise young lawyers in training is that don't take any application for stay of execution or preserving judgment for granted. It's a battle you must also prepare for. And if you are also opposing it, come with an affidavit that is factual and not an affidavit that is wishy-washy and not coming with current authorities. No court will preserve a judgment for you. If you want the judgment to be preserved, you must be ready and handy with the authorities on your fingertips and then persuade the court. And Mabel, I think I should be able to stop at 16:38 now. I don't know how many minutes we have allotted. Maybe we should have questions. We should be able to discuss more in the training than actually reading decisions of courts, reading them without bringing our experience to bear in mind. So, Mabel, I will leave the floor open for questions.
Very well, my lord. Thank you very much. This has been very insightful. There's a question here from Olusegun Ikukoriji. In fundamental human rights action, where the applicant seeks declaratory relief and asks for injunction against law enforcement agents, where the case of the applicant fails, does the applicant, in exercising his right of appeal, have to file an application for stay of execution? Or what can the applicant in this circumstance do to prevent the law enforcement agent from arresting him pending the hearing of his appeal?
Well, he has only given a situation where the man is not yet arrested. What about the situation where he's even arrested and is in detention and his application has failed? For instance, you file a fundamental right application for a declaratory that your detention is unlawful. By the time a counter affidavit comes before the trial judge, he finds out that there is really a very serious allegation against you. You are not just held for nothing. And if the application fails and is dismissed, again, you can go up and challenge the application in the Court of Appeal. Again, in your application is your duty to convince that trial court, even though it has dismissed your application and found it unmeritorious, but the application for stay is a different kettle of fish all over. And at that is why Nikitobi JSC in Oduntan case said, the state of the law is fairly worried by this burden. The trial judge is made to determine the strength of his own ruling or decision. This is because he cannot validly determine whether or not the appeal is frivolous or arguable unless he goes into the strength of his own ruling or decision. While the point is considered that it will be put in too strongly to say that by this body, the trial judge is made to sit on judgment over a case he had done or is doing. The procedure is fairly embarrassing to the trial judge, he continued. While the law expects a dispassionate analysis of the merits of the appeal on the part of the trial judge, it will be highly pretentious on the part of the law to forget that the trial judge is just one human being. So in fundamental rights, if your application is dismissed, it's a sui generis procedure. You go to Court of Appeal, you can also apply. It's just like when a trial court refuses you bail, and then you go to Court of Appeal, you also ask for bail. But I know declaratory reliefs in fundamental rights too, sometimes, if I make an order, the release, the detention is unlawful, and then you did not release the person, you go on appeal and you come before me to ask for stay of execution until the appeal is determined, I would also look at your conduct. You are in disobedience of the court order. So fundamental rights cases should really be looked at carefully, although we are dealing with a species of superstitions, they are sui generis. If there is a prayer for declaratory relief that the detention is illegal, the fact that he is not arrested, for me, is immaterial. Even if he's arrested, he's in detention. If I refuse the application, he will remain in detention. If I also refuse the application, they will pursue him. They will run after him and arrest him. It's left for him also to go to the Court of Appeal and apply. But he can come to the trial court to ask for a stay of execution. But what stay of execution are you asking? The judgment is merely declaratory. There is nothing to enforce. There's nothing to execute. Nobody is going to be arrested. You are the one that came to court that you should not be arrested, a declaration that you should not be arrested. The court did not declare that the law enforcement agencies should arrest you. Mabel, I hope I understood the question.
Very well, very
Yes.
well, madam. Thank you very much. There's another one here. Can
Yes.
I proceed with execution of a judgment before the High Court after judgment debtor's motion for stay of execution at the Court of Appeal has been struck out, although the appeal is still pending?
You see, of late we'll have this problem of appeal being entered. The appeal entered, you cannot do anything. Once an appeal is entered, the whole proceedings are now transferred to the Court of Appeal. The Court of Appeal is seized of all the matters. I wonder how, in those days, the entire file, the entire process are taken to Court of Appeal. When you come back to the trial court, I don't know which process. Are you going to open another new file or you are taking the judgment to another state to go and register and enforce? For me, as a trial judge, I've been in the gateway court. If there's an application for stay of execution, because an appeal does not operate as a stay of execution, as a stay. So if you do not apply for stay, we enforce the judgment. It's the sheriffs that will enforce. If processes have already been given out and your appeal is struck out, or an application in the Court of Appeal is struck out, why will the trial court be eager when an appeal is entered, when it no longer has jurisdiction? Why will it be eager to enforce the judgment when the appeal is not before, the matter is not? Remember, the entire process is one. The fact that you have gone to Court of Appeal, the parties are the same, except there are people who did not go on appeal amongst the parties. Some parties may not appeal. You can go after them. If there are 4 defendants in the court, 2 appeal, 2 did not appeal, you can continue your case against them, especially if it's monetary or you claim on that. But if the cases are so intertwined, I would rather you allow the appeal because processes are no longer before you. Once appeal is entered, you have no, what jurisdiction do you have? Unless you can show me I have jurisdiction to continue. But I have also seen it in the trial court where people will even want to go and carry execution. Another court can execute judgment of another court, but we must be very careful to make sure court processes are not abused. Yes.
Thank you, my lord.
Yes.
For this anonymous attendee, please, how many days do I have as aggrieved party to file my notice of appeal? And is it the same with stay of execution?
Come on. Appeals are guided by rules of court. Nobody in our profession should ask how many days do you have. Is it a criminal appeal? Is it a civil appeal? Is it an interlocutory appeal? Is it an appeal even interlocutory that I need leave? These are elementary. They should look at our rules. I have retired almost 2 years now, but I do know interlocutory appeals will be filed within 14 days. If you don't file them within 14 days, even in a trial court, the trial court will have no jurisdiction to extend time. You have to go to the Court of Appeal. And no lawyer should now ask how many days do we have. Look at the Court of Appeal rules. Look at the Court of Appeal Act. How many days do you have? These are elementary. I don't think in this training, we shouldn't exhibit regrettable ignorance. In this training, we should be able to know some of these things. They are too elementary. I'm so sorry if I'm hard. I assume everybody knows how many days. If it's 30, if it's 14, it's 15, we should not bring them. I understand this is also an international seminar. And no lawyer should ask how many days do you have. Go to your rules of court. Do some reading, do some work. Open your rules. Look at how many days you have. This should not come up in this training, right? Unless we are dealing with law students. Not at MBA level. I'm so sorry.
Someone here says, I must say, my lord, that this is most expository and practical. And my concern and question is, why are practical lectures as these not incorporated in law school curriculum? Most grateful, my lord.
Thank you. You know, sometimes it's very difficult. Mabel, you've appeared before me on the bench, and I'm sure if I was sitting in Lagos division and the lawyer asked me how many days, has to know how, you know what I would say. I'll just say, call the next case, please. You shouldn't waste my time. Anyway, but actually, I want to tell you something practical. Whilst I mentioned a case in the paper I'm circulating, it's a case of MV Jorita. MV Jorita was an admiralty matter that came up in Port Harcourt. Vessels were arrested, and an order was made to release the vessel. and they all had cargo of cement. The cargo, and then an application for stay of execution came before me. Learned counsel for the defendant filed an affidavit and said, look, we have brought this cargo to Nigeria. We are ready to discharge the cargo. We have not breached any of the provisions of the bill of lading, but the government of Nigeria will not allow us to discharge the cargo. So for this court to grant an order of stay, the cement is already caking. And once it cakes, the ships too are going to sink. In fact, when that application came before me, it was argued then by Learned SAN. In my ruling, I found it very simple, that the arguments of Mr. XYZ, Learned Counsel Respondent, is unassailable. If the vessels are carrying a cargo of cement and we stay execution of an order releasing the vessels are going to sink together with the cargo. It's akin to a pregnant woman after 9 months, not allowed to do, after the gestation period, is not allowed to deliver. In fact, it made my ruling very easy. What reason will I give to order for stay of execution in an admiralty matter on a vessel carrying cargo of cement? And these are things that practically in schools should be taught. You can't bring an application for stay of execution for release of a vessel. Of course, we know vessels are being bunkered every day. Of course, Admiralty law now, at least I believe, are being taught in our university. I never read Admiralty law in the university. I never had practical experience. But when I went to Federal High Court, the original judicial, I had no choice but to burn the midnight candle. So sometimes courses that are not taught in the law school, you have to read them. In fact, advocacy itself, you will get it. You have to come to court. Don't just finish your case and carry your file and go away. If there is a case that is sensitive that you are learning, stay and learn, unless you have something very important in the office to do. In fact, when I used to go to court with late Ayolaja SAN, when we finish our court on attachment, he will go and sit with us in court to watch late Chief J.O.K. Ajayi SAN conduct proceedings. So young lawyers, what they cannot learn in the law school and in the books, or even in Harvard Law School, they should be able to learn it practically. And that is why I say our practitioners should be able to come up also with things that are not even taught of in the university. They should be able to pay attention, read between the lines. That is why it's a learned profession. We are reading all the time. Nobody knows it all. And even sometimes, as a judge, I read applications. In chambers, I read file, I go to court, I'm convinced this application will never see light of the day. But once I'm on the bench, and I sit there, I see the arguments that is tilted, I find that I am wrong. So that is why we must read. Don't wait for, once you finish law school, this is the beginning of reading. The fact that you passed, the university passed the law school, you have not started. Every day, make sure you read one rule of court, one provision of the Evidence Act. Master, it's not about cramming. Read one judgment of the Supreme Court. Read the ratio of the sedanda. Understand why decisions are taken in a particular manner. And that is what makes you a practitioner. Watch cross-examinations. See the way they are being done. Tailor them in your cases. Don't just get to court and be on your phone. Keep looking at your file. You will see something that will prompt you. I hope I'm not talking too much.
Not
Yes.
at all, my lord. This has been very helpful. Can an application for stay of execution be granted with just an omnibus grant of appeal?
If you can show the omnibus grant of appeal will be successful, because like we said, you have to show the notice is arguable. But what is an omnibus grant of appeal? Decision is unreasonable or warranted, having regards to the weight of evidence. Well, it is left for you, between you and the trial court, who is granting, or if they don't grant, then you go to. Of course, sometimes it depends on the circumstances. These are not questions of yes or no. If there's an omnibus ground, and I find out the court has no jurisdiction totally, or for instance, there's an order that 12 strokes of the cane should be given, and I know we are dealing with Apima. If the 12 strokes of the cane are given, what happened? Will the Court of Appeal remove them? If the omnibus ground of appeal can show that I shouldn't be caned, fine, or the thing should not happen. It all depends on how you argue. And if also the omnibus ground shows that there is nothing, there's no reason why on earth the trial court should have given judgment against a party, it may succeed. It depends on the judge. If you can convince me with an omnibus ground that the case ought not to have gone in favor of the other person, why not? That is a discretionary remedy. And you must prove, you must convince all the time. Yes.
Thank you, my lord. Where
But
the judgment
I've stayed proceedings with an omnibus ground, but I had a second one that the court had no jurisdiction, and truly the court had no jurisdiction. It was a land in urban area, and an area court granted all the injunctive reliefs and declaration of title, and I went to court with an omnibus ground and another ground that the court had no jurisdiction, and the High Court agreed with me. In fact, the lower court refused to grant me stay. I went to High Court, and we have what they call appeals. Before the appeals, I said, look, the land is an urban area. Instead of area court had no jurisdiction. Can I have a stay? And I got a stay. So it's not a matter of 1 + 1. Yes.
Thank you, my lord. Where judgment is given to a claimant and the other party files a stay of execution, but there is no record of the motion being granted, and the court bailies were reluctant to enforce judgment based on the filed motion, what can a lawyer do to enforce judgment?
I think look at Order 32 of the rules of court when I was there. If you fail to compile records within, I think, 60 days, an application for self-execution will not be granted. If you fail to compile and transmit record, it's a condition precedent. No court will give you. In fact, once you file an application for self-execution, I will not even allow you to move it. I'll just point it to the court that the application is incompetent. Ab initio. You have not, the judgment is given in 2023. We are in 2024. You have not compiled records. Why should the court give you, when the rules of courts are very clear that you should compile records within a particular time? Was that the question you asked, Mabel?
Yes, my lord.
When bailiffs are delayed. You see,
There's
bailiffs are a problem. Unless you get educated people who are very serious doing the bailiff work, it's always a problem for legal practitioners. My experience. They will start process sometimes until a day before the case. They start what they want to. I had cases where I've recommended a lot of bailiffs for discipline, where they have failed to. In fact, some even went to execute when a motion for self-execution was pending. Some even went to execute at the wrong premises. We had to report. So these are things lawyers should be very vigilant. It's not just to file process. Make sure a clerk, your court clerk, goes around to make sure the process are served. If you file the process and take them away with you, the judge wouldn't know that such a process is before him, and he may sign writ of execution. Yes.
Thank you, my lord. This is a comment from Aloysius C. Ezenduka. Good to see my lord in good health. The question is, the trend where a motion for stay is filed at the Court of Appeal, and the Court of Appeal decides to proceed with the substantive appeal, and while the appeal is pending, the judgment creditor proceeds to sell the subject property. What is the best way to approach such challenges in the appeal process?
President Duka, you are not allowing me to enjoy my retirement. I think it's a gross misbehavior for someone when a motion is pending to go on. You've had the case of Ojukwu against Lagos State government?
Yes, my lord.
Of course, also read part 20. When the process is filed in court and served on the party, and he goes ahead, there's a mandatory injunction to undo all the things he has done. Because if you allow parties not to settle dispute through the law system, it's a free for all fight. He can set aside the entire thing. In fact, if someone came, there was an order of injunction in the matter before me in Lagos, and somebody during vacation went to another court to obtain another order disregarding the order that was before me. I set aside everything. And the cases are very clear on that. And is it part 23? Who can call the case now? I'm not getting old. You can't go ahead. As a FAT against a Zegbu, the First African Trust Bank, no court word is sold would allow its processes to be toyed with. And see, people should be sanctioned. Lawyers, parties who are involved in that thing can be reported to the Legal Process Disciplinary Committee. It's better to get the process out of your way and do the right thing the right way. You can't do you can't break the law in the name of enforcing the law. I don't think it's proper. Yes. Azenduka, you are welcome.
Thank you, my lord. This from an anonymous attendee. Please, sir, the right of appeal to stay execution, which has been refused at the trial court, does it terminate at the Court of Appeal, or can it be extended to the Supreme?
The law I know is to go to, you apply also in the Court of Appeal. If they refuse, you also apply in the Supreme Court. If the appeal can go up to Supreme Court. You
And
can follow the entire ladder. Yes.
Can a successful party proceed with the execution of judgment where the judgment debtor's pending application for stay is manifestly defective on the face of the application? Right.
Who should decide is manifestly defective? Is that not the court? Come to the court and show the court it is manifestly defective. But you can't sit in the full comfort of your office and say it's defective. Of course, many a times we see hopeless applications that will not succeed, but we still go to court and then oppose it and show that it is hopeless. But you can't sit in your house and say it is hopeless. So I think you should go to court. Let the court decide it's hopeless, not for us. That is why we must be very careful. Many a times I've seen hopeless applications. I couldn't stay in my chambers and say they're hopeless. I come to court, I hear you, I hear both sides. On the bench, I rule the application can never see the light of the day. Have regards to so and so and so. Supposing I sit in my chambers and say it is hopeless, go ahead and enforce. Will I stay as a judge? Certainly not at all. I don't think it's possible. We should avoid staying and say it's hopeless. We should go to court and tell the court it is hopeless. Yes.
Thank you, my lord. If a party files an application for leave to appeal at the Court of Appeal instead of the High Court, which is the appropriate court, and the other party files a counter, where should the counter be filed, at the High Court or the Court of Appeal?
I think the question is very generic. Let us have a practical issue. If I am filing an appeal against an interlocutory application and I did not file it within time, the next place I will go to certainly for leave is not the High Court again, it's the Court of Appeal. And if erroneously I ought to have filed my application in the lower court and I don't file it, that is the whole game. When I was talking at the inception, valid notice of appeal. Of course, at times the rules will tell you an application for leave to appeal is also considered as an appeal. Allow them to go through the process. Errors must be committed, blunders must be committed, but we should not sit down and watch them. We should challenge them properly. I think we should also be very careful in this training to know which court to file an appeal and when to file it. And more seriously, go and look at the court of bench and nation, how grounds of appeals are to be filed. People should look at it very, very well, how the grounds of appeal are to be couched. And if they bring interlocutory appeals, if the grounds are ones of mixed law and facts and they don't get leave, I can assure you the notice of appeal will be invalid and will be thrown out. And on that basis alone, the application can be attacked, that there's no valid notice of appeal. And the court, even though the trial court is not an appellate court, is not determining the appeal, but it can look at the notice of appeal and look at it and tell you there is no valid notice of appeal. For instance, sitting as a trial court, you are not a court of appeal. You file that the notice of appeal is filed 6 months after the judgment. You can sit down there in your ruling in an application for you say there is no valid notice of appeal filed within time. Isn't that so?
Correct, my lord. Okay. Thank you, my lord. If a party files an application for leave, no, I think we've taken all the questions. Yeah, I think we've taken all the questions now.
And I also think we are 1701. Thank you.
Right. The comments here, I'll just run through some of them. Much appreciation, my lord. I think I can't thank you enough for your wonderful presentation, and you made attendance to your lectures. Remain blessed. This is from Ajogu Esquire. They want presentations, your slides, much appreciation. The practical was highly educative and straight to the point. Wishing my lord long life and happy retirement. Kudos to the organizers. We need a copy of my lord's presentation. Please, I'm also interested in the slides and the recordings too. Thank you, my lord, for this presentation. Thank you so much, my lord. Great presentation.
Thank you, it's the labor and I delight in serving the profession I cherish and love. Thank you. Have a wonderful time.
Lots of comments here. We can't thank you enough. We want to thank you for making this a success, right on time, very insightful, interesting, but we have learned a lot. I have noted a lot that I will take home in my own practice. On behalf of the MBA ICLE, Mr. Tola Oshobi SAN, who is unavoidably absent, and Mr. Tobene Ruje, who would like to thank my Lord for taking out his precious time to share his experience, wealth of experience. And we also thank our participants. Tomorrow is another day, same time. Have a very good day.
Thank you. Bye.